Um, as you just heard, we're recording this. Anyway, roll call. Laura Fitzsimmons. Laura.
She muted.
Yeah, who knows what? Yeah, no, I'm here.
Kate Thomas. Joni Easley. Chris June Kiliani.
Here.
Jeff Wells.
Hello.
Hi, Jeff. Susan Bush.
Present.
I'm sorry. Glad you're here. Angela Cook. Lorena Dellinger.
Here.
Joe Krim. Allison Jaffe.
Present.
Harriet Cummings.
Here.
Jared Hickman.
Hello.
Hi, Jared. Justice William Maupin. And Dave Mendiola. We have a quorum.
Great. Okay, I just have a couple preliminary things. I see a bunch of people on this call. Peter, I'm handicapped, special needs when it comes to Zoom. Can you keep track, or Cindy or somebody, when somebody raises their hand during public comment or any other time? Because
Sure.
I don't know how to monitor that. I want to make sure everybody says what they want to say.
Sure.
Kate Thomas is dealing with voting stuff. Eve Hanan is she'll be watching this meeting later. She's got back-to-back meetings at Boyd. Okay.
Laura, I'm actually here for now. I'm going to stay as long as I can.
Okay, thank you. Welcome. I guess I'll turn on okay, so here we go. All right, so we have our agenda. And the first item on the agenda, we've done the call to order and the roll call. Public comment.
We did receive one via email, which has been posted up on the website.
That's fine. And maybe if that's an issue, Peter can address that. It seems like a one-off kind of issue, or if he can't address it, it can be brought to the next meeting.
Correct.
Okay. All right. Does anyone want to make a public comment, which is, you can comment on anything, any of the items on this agenda.
I do, Laura. This is
Franny
Franny Forsman.
Okay.
Yes. I'm Franny Forsman. For those of you who don't know me, I am not speaking on behalf of the plaintiffs in the Davis case, but rather as a lawyer who has practiced for 47 years in criminal defense, is a former president of the State Bar of Nevada, and the former public defender for the District of Nevada. For unbelievably almost 20 years, 3 commissions have been trying to level the playing field for indigent defendants in Nevada. And it has resulted in where we are today. This board should be very proud, I think, of the progress that has been made in the last 3 or so years. But this board also knows that that progress was primarily due to Marcy Reba. And the things that Marcy has done, you'll hear a lot more about that. I don't need to go through the listings of that. The ironic thing is that throughout our struggles, and first let me say that there are at least 3 people on the commission who were there for almost the entire 20-year journey. Joni Easley, Jeff Wells, and Chief Justice Maupin, who got the thing started with the first Indigent Defense Commission. It was the Indigent Defense Commission, and then it was the sort of the statute drafting commission, which was assisted by the Sixth Amendment Center, and now it is this commission. Those are the three entities that I'm talking about. We made great progress, surprising progress, in the last 3.5 years until about a month ago. I fear that the actions of the governor, which if you don't know already what happened, you will know, will jeopardize the progress that we have made. And the only thing that I can say about that, there was another thing I was going to say about during the process of those three commissions, the counties continuously said, we can't trust the state. We can't trust the state. We can't go with the reforms that everybody agrees we need because we think the state will pull the rug out from under us. And I believe that is exactly what has happened. I hope that this board has the strength to be able to protect the progress that you've made from the governor and others who really don't care about whether or not poor people are treated fairly in our courtrooms in Nevada. Thank you for your time.
Thank you, Franny. Does anyone else wish to
Laura?
make? Yes?
Yeah, Evie has her hand up.
Oh, hi. Oh, hi, Evie.
Good afternoon. For anyone who does not know me, and for the record, my name is Evelyn Grossnick, and I am the Washoe County Public Defender. I echo everything that Franny Forsman said, although she certainly has much more experience and knowledge about it. I would like to provide public comment on item number 4. I was disheartened and extremely concerned by Governor Lombardo's recent removal of Marcy Reba from the position of Executive Director of DIDS. I had the opportunity to work closely with Ms. Reba during her tenure in that position, and I was always impressed by her enthusiastic and sincere dedication to improving indigent defense, her 2 decades of public defense experience, and her creative leadership as Executive Director of DIDS. Ms. Reba's removal came at what seems like a particularly unfortunate and critical time given the state's obligations and deadlines under the Davis Consent Decree. The reality is that I think the only way that indigent defense crisis will be solved in rural communities is with sufficient funding from the state, but that is up to the legislature and the governor. Despite that serious need for funding, Ms. Reba was able to implement several measures to improve indigent defense during her time as executive director. She increased the quality and availability of free continuing education programs for indigent defense attorneys across the entire state, not just for rural communities. She successfully lobbied for change to the state bar rules that would allow law school graduates to practice under supervision in rural communities while they take the Nevada bar and await their decisions on admission. And she secured funding for law school graduates to take the bar in return for a promise to practice in rural indigent defense and obtain paid internships in rural jurisdictions. Now, you all know much more about all of her accomplishments than I do, but those were just to highlight the direct impact that she has had on rural indigent defense in our communities. These actions have already increased the pipeline of new attorneys to the rural jurisdictions, which is a significant step in the right direction. That the governor could remove Ms. Reba in the way that it occurred reveals what I think is a serious flaw in the system. I hope that a solution can be reached that will prevent this scenario from occurring in the future. And I would wholeheartedly support amendments to current law to place the decision on the executive director's position solely in the hands of DIDS or any other solution that would prevent this situation from occurring again. Thank you.
Thank you.
Laura, Chris has her hand up.
Chris?
Hi, I want to speak also on public comment period. I don't go back as far as Franny, but I still remember when we were dealing legislatively with creating an indigent commission and trying to make sure that we had proper representation. I have to admit, I was shocked when I saw that Marcy had been removed. I think it was done politically. I think it was done without cause. And I have to say, having been both a state legislator for 16 years and a commissioner for 12 years and a public school teacher for 30, what I appreciated about Marcy is she created this group with her team in a way that was complimentary. It was not invasive to anybody. It was collegial. And to see someone in management be able to build this department up on their own, make the selections of good team members, and then move us forward to have that just snatched out from underneath us, I think that makes me very concerned about how the independence of judgment can be there for the future. And I don't know legislatively if we can come up with something, but I do think that there needs to be a different authority that is answerable to the Indigent Defense Commission or board, sorry, rather than the governor's office. There are some things that are more appropriately not political, and I think maybe that should be something we should discuss down the road as a board. I don't think that Marcy deserved that type of behavior. It was petty, and in the long run, she brought the rurals together to see that we did care from the urbans and that we were sensitive to their issues and their funding streams. And I think there was a great working relationship. And heck, I don't know what the cause was. I don't know if it was Patty. I've known her off and on for years as well. She'd already resigned. Why that was an issue at all is disappointing. But I think we need to be more proactive here to look at what the ED's role and who they're answerable to in the future. And I think legislatively we may have to look at something. But if I, as an employer, I would have given Marcy excellent ranks. She built this Indigent, the whole system with just such ease and such care that I have not witnessed that from a lot of managers in the past. So I just wanted to say something just as an individual on that part of it. Thank you.
Thank you, Chris. And I
Laura,
think
Laura,
Randy-
we got a few more.
Yeah, I saw Randy Fiedler, but
Uh-huh.
anybody else? Randy, you
Um,
want to go?
We have Kate Hickman as well, and I thought I had somebody else. I will keep you posted.
Thank you. Hi, Randy.
Hi, Laura. To put my name into the record, my name is Randy Fiedler. I am an assistant federal public defender here in Nevada. My office provides indigent defense services to individuals charged of federal crimes and to individuals who have been convicted of state crimes. Individuals convicted in the courts of Nevada have a right to file a petition seeking relief in federal court alleging any constitutional violations related to their conviction. Nearly all of the post-conviction petitions our office litigates involve claims of ineffective assistance of counsel, and we have significant experience litigating those claims for convictions from Nevada's rural counties. Our experience has shown us that historically, Nevada has faced challenges in ensuring that the right to counsel and the corresponding right to effective counsel have been respected, again, particularly in our rural counties. The work that this board and the department has been doing under Ms. Reba's leadership since the department's founding is critical to ensuring and enforcing the right to defense counsel. It is of the utmost importance that our rural counties provide legal representation, investigation, and expert assistance to litigate cases and provide constitutionally mandated defense services. Failing to do so requires these cases to continue on into state and federal post-conviction proceedings. It is better both for the state and for the defense for these cases to be litigated properly in the first instance at the trial level instead of going on into post-conviction. Thank you.
I got to unmute. And thank you, Randy. And Kate Hickman.
Hi, good afternoon. Thank you. For the record, my name is Kate Hickman. I'm currently the Washoe County alternate public defender, and I'm the vice president of the North for the Nevada Attorneys for Criminal Justice. I have been a public defender since 2009 and have worked in 3 separate offices. I've worked in the Colorado State Public Defender's Office, which has a statewide system. I've worked in the Washoe County Public Defender's Office and now currently in the alternate Public Defender's Office. I have a couple areas that I do want to make my comment on. The first is agenda item number 4. I echo everyone else's comments about Ms. Ryba. She did incredible work for indigent defense in the rural jurisdictions and also for indigent defense as a whole in Nevada. I specifically want to commend and address her advocacy for adequate funding for the state public defender and contract attorneys, the training that she worked on, regulations, and ensuring that attorneys are qualified to handle the cases that they are appointed on. And also for her push for independence of the public defender system. DIDS is an incredibly important body, and there needs to be significant resources allocated to ensure that it continues to rise to the challenges of ensuring that defendants are zealously represented in the entire state. The second thing that I would like to address is agenda items 6 and 7. The recent posting for recruitment of the executive director gives me serious pause, and it's what prompted me to attend today and give my public comment. I spent yesterday reading the materials for the meeting, and I have serious concerns about the erosion of the independence of DIDS and the public defender system from the executive branch. The very nature of public defense is that we are attorneys that are paid by the government, but we are not government attorneys. DIDS is going to have policies, funding requests, and positions on issues that are not in line with the executive branch and often could be in direct conflict with the executive branch. The executive director, her staff, the state public defender have to be able to take those stances in the interest of indigent defense without fear of retribution or termination because they are not in line with policy positions of the executive branch. In line with those concerns, in reading the emails between Ms. Ryba and the AG's office and with the governor's office, I'm concerned that the same agency that represents the executive branch will always represent DIDS. In some of those emails, there appears to be a very direct conflict of interest, and there needs to be a mechanism that DIDS can seek independent counsel when its interests are opposed by other agencies or offices such as the governor's office that is represented by the AG's office. As to item 6, compliance with Davis is always going to be severely limited as long as there is the deliberate choice made to continually underfund the state public defender's office. In the emails, there is a suggestion that the executive director, Ms. Ryba, and her staff, instead of running DIDS, accept cases. There was a suggestion that Ms. Ryba seek the AG's office to have deputy attorney generals accept criminal cases. But what those emails reflect is underfunding and low pay that contributed to a high turnover rate, and ultimately the inability for the office to provide zealous representation to some of the state's most vulnerable populations, which is the mandate of Davis and the Constitution. Those systemic problems can be solved with adequate funding, and it has to be addressed immediately to ensure that compliance. Finally, I want to address agenda item 5, which is the lack of qualifications and the performance issues of the Nevada State Public Defender. It is heartbreaking to hear that the head of the State Public Defender's Office was not offering mitigation for her clients to the point that the district attorney is offering such mitigation. This is intimately tied to my earlier comments, which is lack of funding that leads to a dearth of qualified applicants and a lack of independence that clearly limited DID's ability to provide oversight of an unqualified employee. In the future, the lack of independence and the fact that the termination of the executive director came from the lack of oversight is an issue that the board should look to address. Further, the lack of funding and resources put the head of the state public defender in a very difficult position. She was forced to handle cases that she was not qualified for and unable to handle the administrative duties that the office requires. She was put in a position to fail, and DIDS was in a position to fail because there's not adequate funding, there are not adequate resources, and the state public defender was put in a position to wear too many hats. And I think that all of those are going to continue to give issues with compliance with Davis. Thank you.
Can I ask a question? This is Bill Moppin. Can I ask a question?
Laura, you're muted.
Got it backwards. I just want to say, I'm not good at this stuff, but ever since Marcy got fired, I haven't really been sleeping. So that's my new excuse. Please, Justice Maupin.
You mentioned that someone came up with the idea that deputy attorneys general should be handling criminal cases out in the rurals. Who was it that came up with that idea?
That was it's in the material. It's the governor's finance office. It was a suggestion, and fortunately, I believe Craig Newby wrote a letter saying that that dog would not hunt, that they couldn't do that. I mean, that's a clear conflict. There was also just, it's in the materials, a suggestion that from Jim Wells, who's the governor's, I guess he's the vice chief of staff, but he's the finance guy, that Marcy and her staff go out and start representing clients, and that all agency heads have to pitch in now and then. It's in the
That is none. Okay, I'm going to interrupt you right there. That is absolutely none of his business. And the only reason that this office is in the executive branch is because of a stupid concession who by someone I will not name at this point because it's not necessary anymore. That this should be in the executive branch. That is, so that we wrote into the statute a provision which makes our executive director a statutory where the executive director has a statutory contract of continued employment, which was violated by the governor's office by treating this person as if she was an appointment by patronage. That's, I have more to say, but I probably need to cool off.
Thank you. Thank you, Justice Maupin. Is there anyone else? I'm hearing blowback, but anybody else want to speak in this portion of the agenda, which is public comment on an agenda item? We will also have an opportunity at the end of this meeting for additional public comment. Okay, hearing or seeing, Peter, are you keeping track? Nobody's raising their hand?
No hands raised and nobody else has indicated they want to speak in the chat.
Okay, thank you. Now, item number 3 is the approval of the minutes from August 22nd, which is back when things looked like they were going in the right direction and days before Marcy was terminated. Has everybody had a chance to read the minutes? Good job, Cindy, that were prepared of that meeting. Does anyone want to make a motion to either amend or approve the minutes?
I would move to approve.
Okay.
Or I'll second after, it's Allison, I'll second after Jim. I think it was Jim who made the motion.
Jeff?
That was Jeff.
Okay, Jeff Wells. Okay,
Yeah,
great.
Jeff, not to be confused with.
I know,
criminals.
and that has happened to me.
Yeah, right?
Jeff has
I
been on
defer to
board with
Jeff.
this. Okay, so all in favor, say aye.
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 Anybody opposed? Okay, the next agenda item is recognition of the service of the executive director, Marcy Ryba. Now, our poor Dag and I've been going back and forth for weeks now. My understanding is that it is, and Todd, correct me because we frequently disagree. If every member of the board has received this statement by the board on indigent defense services concerning former executive director Marcy Ryba, it's in the agenda material. First, we can discuss this, and then if it's appropriate, the board could move to approve this statement. Is that correct?
Yeah, to adopt the statement with obviously, majority vote, yes.
Thank you. All right, has every board member had an opportunity to read the statement that I've just referred to? I won't read the title again. Okay, everybody's nodding. Does anybody have, I know one comment that I heard was that the lasso program was something that was really remarkable that Marcy did, and that could be, we could talk more about that in this letter. Something else that makes me, we could add to the letter. Marcy, many of you saw Stephen Bright, who spoke at Boyd. And many members of the Boyd community and the criminal defense bar in the state were able to listen to really one of the, there's all kinds of adjectives I could word about Professor Bright. He came to Boyd because Marcy cold called him. She just called him out of nowhere. That's Marcy. And she got this inspirational titan of criminal defense to come out to Nevada and speak to our defenders and inspire potential defenders at that law school. So that's not in this statement. Does anyone have any edits or anything? I mean, we could go on and on, but does anybody want anything taken out of this statement?
Madam Chair?
Yes.
It's Joni Eastley in Tonopah. My position hasn't changed since we had a discussion with the DAG, and that is I have no problem with the essence of the letter, with the exception of the first and last paragraphs. The governor, as much as I don't like the action that was taken, I am familiar with Chapter 180 and the fact that she serves at the pleasure of the governor, and he has no obligation to consult with DIDS before he took the action that he did.
Okay. Does anyone does anyone want to respond to that, or we could just move for a vote on whether?
It's my comment. We don't need to debate it.
I understand, Joni, but as you know, we respect your opinion, and that has been a consistent opinion of yours. So I just want to make sure that you feel that you expressed it fully. And
yeah, it's not about Marcy. It's about the statute. It's about the law.
Okay. All right. Does anyone want to make a motion?
This is Chris. I'd make a motion to approve sending out the letter and note Joni's concerns.
Okay. I'm not sure, Chris, just to address it. I don't know if we're sending this letter out.
Okay.
I don't know who it would be sent to. I think if it could just be adopted.
Okay.
And on our website, and Joni's concerns absolutely will be in the minutes. Does that work for you?
Yes.
Okay.
So, yeah, amend my motion to be that we accept the letter and post it wherever
Second,
you decide to.
Okay, who seconded it?
Bill Moppin.
Can you second if you can't vote, Justice Moppin?
If he can,
No.
Okay, Jared is, who is?
I will second.
Okay, all in favor, say aye.
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 And
Aye.
opposed? And Joni?
Opposed? Eastley votes no.
Okay, all right, so that
And
motion.
I will express my personal regret of not having the sophistication of Robert's Rules of Order that I should have.
Thank you, Justice Moppin. All right, so that motion carried, and as Chris pointed out, this will be posted on our website as adopted. The statement is adopted by the board. The minutes will show how the vote went and Joni's reason for her voting no. Okay, this brings me to a couple of things that were addressed in public comment. And the documents are posted on the website under RIBA termination 001. And I'm just going to briefly go through it because I ended up being very involved in this. And I know there are people on this call that question, even one of the speakers, I think it was, said that they didn't understand the purported reasons for termination. Following up on what Justice Moppin said, those of us that have been on these committees recognized, and Ms. Hickman pointed out the essential tension between the executive branch and the role of the indigent defender. And that is why the statute reads as it does. Concerning, as Justice Maupin referred to it, a good, basically, this is a statutory due process right in our executive director to continue to employment absent certain things. I'm getting into this now because we are still looking for a new executive director. The position has been posted for at least 10 days and we have not had a single applicant. And I don't believe that, I think it's going to be very difficult to have an applicant. But I did finally, and all this is in the material, after I learned Marcy had been called in and terminated without any real back and forth conversation by Ryan Cherry, I contacted him repeatedly and went over to meet with him. And he told me, and it's in the material, that there were 3 reasons for Marcy's termination. One was this purported error, I guess, by her office in double billing for the post-conviction bills. As we recall, on June 12th of this year, the Nevada Current ran a story because lawyers who were performing representation for post-conviction people were not getting paid. And apparently that generated finally, all the documents are in here, Marcy had been directed to hold the bills because there was no funding. And when the press reported on it, there was a request by someone in the governor's office or the finance office for a list of the bills. And the circumstances of that are set forth in a memo that's contained, RIBA termination 009 to 010. There was never double billing. There was 2 ledgers sent over just with running tallies of the post-conviction bills that had been accruing because there was not sufficient funding to pay people who were doing the work. So that was number 1. Number 2, Ryan Cherry told me there had been a dispute between Marcy and Ms. Cafferata. And number 3, he told me he had difficulty. He had been trying to reach her all week. He had texted her Monday morning, blah, blah, blah. Anyhow, I had gone, and I'm babbling, but I'm going to stop babbling, but this needs to be told. When Marcy met with Ryan Cherry at 11 o'clock that morning, he handed her a prepared termination agreement and told her the same 3 reasons he ended up reiterating to me, one of which was I couldn't reach you on the office cell phone. So what happened after Marcy was terminated, she went back to the office that she created, and there was law enforcement waiting there. There was, I don't know if it was Capitol Police or a marshal, and she was allowed to only take her personal things out of that office. And the phone was left in the office, cell phone was left in the charger. So it was undisturbed until I got over there to take screenshots, which showed that Mr. Cherry had not, in fact, repeatedly tried to call Marcy. And when he actually called her on the office line that Friday morning, she went right over, only to get fired. The other thing that happened later that day, which is of profound concern and will be, I hope, addressed in item 6, Jim Wells went over, and I mean, the office is in an uproar. You've got law enforcement there, and Marcy's being frog marched out. He talked to Peter Handy, and he appointed him acting executive director. And he gave Peter several directives, which are reflected, many of which are reflected in an email that Peter ended up sending back to the governor's office. When I met with, and I want to tell you, I don't think the governor knew about this. This is, in my opinion, not about the governor. The governor's got a lot of things going on, and I think this was a tribal and ill-conceived and really quickly arrived at decision by the chief of staff and by Jim Wells. When I went over, I told them what this would mean to indigent defense. I gave them an opportunity. I mentioned I didn't think the governor had been briefed, or if so, he'd even been adequately briefed. But here we are. Nothing's been done. Jim Wells, and this is in the material, followed up and told me he would send something saying, I said, we need to know what you think your authority is over dids and bids. And what are, where are we here? Because, and he said he would send something and he never has. So that's where we are on this. I'm just getting into that because you can tell I feel strongly. Many of the people who have spoken feel strongly. And I'm just giving a full rendition of the facts that led to the termination of our executive director. Okay, so now we're moving on. And anybody else have any comments on that?
Laura, if I could, this is Jared Hickman for the record.
Sure, Jared.
The public comment, most of the public comment took, my feelings and concerns, directly out of my mouth. I don't know that I could say it any better than it's already been said. But I do think the statute provides a due process right
Yes.
that was not followed here in relate as it pertains to the executive director. There is a finding that must be made, and I don't see from any of the materials that has ever been sufficiently stated or made, and that gives me concern regarding the independence of the department and this board. I was with Marcy in a unique position. For a board member, I was with Marcy when the department started and worked with her for about 2.5 years, getting the department up and running. And I will tell you that in those initial battles, independence was, the independence piece of the defense function was our primary battle. And, that extended from, the public defenders and the judiciary to, us and, at the time, the governor's finance office. And I think that relationship has gotten a lot better. But now it appears that it's the governor's office itself. It is critical to protect the office from political influence and will. As the public comment stated, the public defense function is not often popular. It shouldn't be subject to popular influence or will. And I think Marcy's apparent termination without that statutorily prescribed cause or finding, threatens the ability to carry out their central mission of providing ensuring that constitutionally adequate defense is provided. And I know it's not on the agenda for today. I would hope that in the future, we have an agenda item that allows us to discuss, legal recourse, if appropriate, whether that's a writ, whether that's a deck action. I also share concerns about, apparent conflicts of interest. And a future agenda item might be appropriate to explore that via formal letter or question to the AG's office. So with that in mind, I'd just like to share those and hope that those can be future agenda items as we move forward.
Thank you, Jared. And just for those of us on the call that the conflicts of interest, and this is not personal to Todd, who has really stepped up and been responsive to us, but the Attorney General's office, Todd, I'm not talking about you. There are lawyers, they're Patty Cafferata's lawyers, they're the governor's lawyers. They prosecute the prison cases in Whitebine County, where Ms. Cafferata is practicing, and they're one of the parties in Davis. So just institutionally, we do have a concern that if this were to move forward, I mean, what's happened with Marcy tragically happened to Marcy, and we can try to pick up the pieces and move on. But as I told Ryan Cherry when I met with him, unless we figure out how we can protect, and we thought we had protected statutorily our executive director. The governor's office apparently disagrees. How can we have an executive director who under our statutes works under our direction and reports to us? And think of all the meetings. I've only missed one meeting in 5 years, and most of us are like that. Why are we doing this if we are working cooperatively with the executive director and her staff, and then out of the blue, she's terminated for she or he, whoever the next one is, is terminated for doing too good a job. I agree. We need to find a way moving forward to ensure this never happens again. Anybody else?
Chris has
Chris?
his hand up.
Thank you. I have 2 points. Thank you, Jared, for bringing that up. I thought when we did the statute that there was more authority for the board and the executive director. So obviously, I think we need to file suit or something to verify whether or not that language is what we all thought it was. And if not, come up with language accordingly. My second point would be to Peter, if you don't mind, and I don't want to put you in an awkward position, but when the governor's people came and gave you certain directives, were they directives that you had to do that the board was not aware of, or it was outside of your area, like telling you to go argue a case someplace else or something along those lines?
Nothing to that extent. It was
Okay.
Most of the things are identified in that email that Laura referenced earlier.
Okay.
And most of them are things that the department does and are continuing to do. Some of it was just a shuffling of duties between the NSPD and the departments conducting those duties.
But to follow up on that, the dispute between Ms. Cafferata and Ms. Ryba was that Ms. Cafferata did not feel that her office should pay the post-conviction bills, even though in the statute, it says they come out of her budget. She didn't want to do it.
Well, perhaps it's because she had no criminal background in the first.
Right, there may be that, but she then, just so everybody knows, and we'll move forward. She then, as David Sheik says in her report, announced in White Pine County she was leaving. She wrote Marcy a letter or she wrote the governor a letter saying she was leaving. This all happened right after that great meeting we had. Actually, there are people that were on the Zoom call that told me later Patty was actually standing up and taking stuff off her wall and putting it in a box. I didn't see that. But she didn't want to pay it. So she went to the governor, said she was resigning. I think really she went to Ryan Cherry. And that's when you'll see the text. There's a problem, stand down. And then Marcy got fired. She also, following up on what other speakers have said, 2 things happened between that great meeting and her getting fired. One was Patty went to the governor's office, and the other was Marcy requested, in order to comply with Davis, this is in the materials, she requested $2.3 million because we couldn't fund the public defender's office, and for 10 contracts for Davis compliance. She got terminated after those 2 things. And Peter, my understanding is you were either told by Jim Wells expressly, or somehow it was communicated that idea of funding for compliance with Davis for contracts is certainly not moving forward. Is that a fair statement?
Right, yes, that was that same meeting, the same day Marcy was removed. He indicated that the amount for the additional contract in White Pine County and for the justice tax would move forward, but that the additional amount for the contracts would not be.
Okay.
So it sounds like there's an education problem with the finance department not understanding what the role of DIDS is and trying to micromanage it as they would with any other state agency. And we're different than the typical traditional state agencies. So I think that's just another thing that needs to be worked on. So it sounds like it was a double whammy that hit at one time, but I kind of suspect you're right. I don't think the governor was actually the one that was involved in this. I think it was Mr. Cherry.
Well, I think you're being very generous in how you pointed that out.
For me, that's pretty good. Huh?
So the problem is that the executive branch prosecutes criminal cases. And so the executive branch is now controlling the purse strings of the ability to provide due process to indigent defendants. It's as simple as that. That is forbidden territory.
Okay, any other comments?
Madam Chair, I don't want to stifle any discussion, but we need to move into an actual agenda item to continue these discussions. I know these are kind of a mix of the next to agenda items, but just for clarity's sake, I want to make sure we're actually in an agenda item, especially agenda item number 6, because I believe the NSPD has their own counsel who is attending on her behalf, and I want to make sure he has an opportunity to respond and participate as needed.
Okay, are you saying that we should be discussing now specifically agenda item 5? And
I'm
then
sorry, agenda item 5. Yes, whatever the next agenda item is, let's make sure we're staying on schedule.
Okay, well, I don't know if there's a schedule, but here we go. So item 5 is these concerns about the performance of the state public defender. And I think you guys have this. We had to continue this meeting to comply with the open meeting law requirement that the public defender be personally, that whoever, an employee whose qualifications and performance are going to be discussed needs to have actual notice. So that was provided to Ms. Cafferata. I think you have the email between me and her where I think she's at the Hoover Institution. I don't know where she is, but she did indicate, Todd, chime in pretty quick. I know she's your client too, but pretty quickly to you, she indicated she wouldn't be here and that her attorney wouldn't be here either. I sent her everything, all the documents that we now have on this agenda item, at least early last week is my recollection. And now you're informing us that Ms. Cafferata does have an attorney who's present.
I don't know for certain. I would ask if Ms. Cafferata has representation on the call that they announce their presence now, if possible.
Thank you, Mr. Wise. This is Rue Goodnow. And thank you, Ms. Fitzsimmons, for the opportunity to talk briefly with the commission. As you know, Ms. Cafferata is attending a program at the Hoover Institution and was unable to be present. She does intend to respond and has asked me to represent her interests personally, not the interests of her office today.
Okay, is there anything, Mr. Goodnow, we're glad, welcome. And also would you like to speak representing her personal, was it her personal interest, but not the office?
Right. To put this very succinctly, Ms. Cafferata had some concerns with respect to her reputation because some of the issues raised could reflect on her. And so she asked me to be present so that I could help her to address those. From my perspective, I don't think there's anything that needs to be addressed at this point. It sounds like the discussions of the commission have primarily centered around the issues and longstanding issues concerning funding for indigent defense services, and then also the tension, as you identified, between the control over representation of citizens accused by a crime and the purse strings, as Justice Maupin eloquently put it, that are held by the public coffers, and of course Ms. Cafferata understands that, and I'm sure that we'll address any concerns that the commission may have, and I'll ensure that she's informed about those concerns.
Thank you, Mr. Goodnow. I want to make sure that we have posted because on this agenda item, you're correct that these things that you summarized have been addressed, but I need to make sure you do understand. For agenda item 5, there is a grouping of documents that actually address Ms. Cafferata as a public defender, and that you've had an opportunity. I sent them all to Patty, at least a week ago. But I want to make sure you've seen those. They're reports from district attorneys, judges, our DIDS compliance observer, things like that. I want to make it clear that, first of all, let me ask you, have you reviewed those documents? They were sent to your client quite some time ago.
Quite some time ago, is a subjective
That's true.
characterization.
Yeah.
I only just received them, and I don't believe that Ms. Cafarata had a chance to review them until very, very recently.
Okay.
As you know, her office is busy, very busy, and I know you were also informed concerning her schedule. So
That's
I
correct.
do know that she has received the agenda items and has looked at them and intends to respond. Was simply unable to do so today.
Okay, that all makes sense. Could we ask if she could respond within, I think I sent it to her. Does anybody have a copy? I sent it to her at least a week ago, which if, with my schedule getting ready for this hearing, is quite some time ago because of lack of sleep. But when do you feel Ms. Cafarata could respond? And I understand from our DAG that it's going to be in writing and her response would be made part of this record. Is that correct, Todd?
That's correct. Yeah, if she submits a written response after the meeting, we can include that as part of the board meeting materials.
Could she respond in a, I understand, which is very alarming. We'll get to that. She has a felony jury trial in White Pine County next week. Do you think 14 days from today would be adequate?
She actually has a couple. Chairman Fitzsimmons has a couple of trials scheduled, and you've just mentioned one of them. I know. So 14 days does seem like a bit abbreviated for that response.
What's her second trial? I know she has a felony trial starting next week in White Pine County. And that's a jury trial. What's her second trial?
And I apologize. I don't know.
All right. Well, you'll see why I'm concerned about that. How does 21 days sound? Does that sound fair to you?
It sounds fair to me. I haven't had a chance to consult with Ms. Cafarata.
Okay. Well, we'll shoot for that. Could you please let us know, and that, I mean, Todd Weiss, Peter Handy, and me. Peter's the secretary to the board. If you need more time than the 21 days, is that fair?
That seems fair.
Okay. And I want to make something clear also. We all recognize that your client has decades of service to the state of Nevada in numerous positions. And she is a state, she knows more about the history of Nevada and its courthouses than anybody. And this is not personal. Okay. The only thing this board is going to be talking about with respect to Ms. Cafarata is whether or not she has the experience or training and ability to provide constitutionally adequate defense to indigent defendants in Nevada. That's it. So I just want to make that clear. This isn't personal. This is part of what most of the board, I think Joni may disagree, believes is our primary reason for existing. And when we have a state public defender who is not performing in accordance with the Sixth Amendment right and through the 14th Amendment, that the state of Nevada itself has expressly accepted responsibility for and to ensure, we have to talk about it. So that's why we're here. And thank you for being here. Okay.
Chris has her hand up.
Who does?
Chris.
Hey, Chris.
Hi,
Oh,
sorry,
I see your hand. Hi.
just to clarify. So the discussion regarding Ms. Cafarata is regarding the office itself that she was serving in. And the issues that rose on that. Nothing that's a personal discussion of her as an individual.
Nothing personal about her. To the extent that personally, as just any indigent defense lawyer, her qualifications just in that one narrow category are something we need to examine and see if we can remedy. That's it.
Okay, and so ignorance, she did resign, so she's not in that role any longer. No,
Oh, no, Chris, Chris was in Paris. Is that too much?
sorry.
She resigned. She wrote the governor's office a letter saying she was resigning. She then met with the governor, and Marcy was fired, and Patty has never resigned. She's still there. She's actually going to be representing the people we're supposed to be protecting in at least one upcoming felony jury trial, and now we're hearing perhaps two. So this is an ongoing.
Okay, all right, that clears in my mind then. I'm like, why are we talking? Okay, yes, then we do have to look at qualifications as well as capabilities that are there, and based on the letters and the back and forth. That's a very legit discussion for us to have as a board. Okay, thank you.
Has everyone read, first of all, the oversight NSPD bait stamp documents, which begin with Patty's resume and end with her explaining why she can't fill out the form. She's too busy to fill out the form to apply to be qualified, which every lawyer is required to do. Has everybody seen that?
Yes.
A bunch of material. I want to begin this. You know, it's funny, a lot of us have talked about all the work that's gone in, and it's not just the people here. I mean, so many people, so many judges, legislators, stakeholders, defenders over, I think, 17 years have worked on this. And one of the benchmarks of our work was the right to counsel evaluation of indigent defense services in Nevada that was published in September 2018. That was the outgrowth of the Senate bill, which was one study committee that gave rise to Chapter 180. And, you know, when you look back through history, on the executive summary, page 5 of the Right to Counsel report says, this is 2018, the state of Nevada has only very limited oversight of primary representation in just 2 jurisdictions, Carson City and Story County, that use the state public defender. However, the state public defender system suffers from undue political influence, interference, and inadequate funding. And I just want to summarize, it's done in a timeline that is posted that, thank you again, Cindy, was sent out this morning. It summarizes how, because of the inadequate funding of the State Public Defender Office, which has been of consistent concern to our Davis Monitor, to DIDS and this board, the salary range is so low that it has been impossible or very, very difficult to hire anyone to work in the state PD's office. And it's in this context that Patty Cafferata applied to work. Her resume's at Oversight 1. And so she went to work. Chris Arabia, who was a seasoned trial lawyer, hired her. There was no one else to hire, and there were a bunch of openings. We have openings in the state public defender's office for attorneys that have been open for over a year with not a single applicant. So Patty applies, she gets hired, she goes to Story County, and immediately, and you can see by the letters, it's unpleasant to talk about this, but you know, the Story County DA wrote a letter pointing out constant and pervasive problems with Ms. Cafferata's performance, concluding that the current situation is untenable, potentially compromises the constitutional rights of the accused, and creates a risk of liability exposure to the county. It cannot be allowed to persist. So at that point, this is May of 2023, DIDS went up. They did an on-site visit. They interviewed the Justice of the Peace. I will tell you that I think Ann Langer also sent DVDs of Ms. Cafferata in that Justice Court, and I have those. It was as painful to watch as, I mean, it was awful to watch that. I think that's kind of performance is what the DIDS staff saw. They observed her in court. They agreed with the concerns. But all they could do at that point, Ms. Cafferata was working for Chris Arabia, and he was unable to hire anyone else. Their conclusion was, while many of these issues could be remedied with additional training or shadowing by and with more experienced criminal defense counsel in the SPD office, currently there are no such counsel available. In short, the best option is to let Story County come out of the state PD system and go into the newly created and very good office, the Carson City Public Defender's Office. So Marcy Ryba knew that. Okay, she wasn't one of the people up there. I will point out the board never knew anything about this, but the complaints about Patty Cafferata's performance in court were known to DITS. When Story County fell out, Ms. Cafferata stopped going to court. So problem solved in a way. But then Chris Arabia, he resigned, and Ms. Ryba wrote the governor's office on January 10th saying, Chris Arabia resigned. Let us know what we can do, Marcy or our board, to help with the new appointment. That's oversight page 7. The governor's office, she wrote that on January 10th, no response. She wrote again, same thing on January 22nd, no response. On February 21st, Ms. Ryba met with the governor's staff, and she was told that somebody, some mystery person, had been approved to be the new state public defender. That's oversight 11. She didn't know who it was. She said she was excited to find out. And then Ms. Cafferata, not the governor, on February 29th, wrote Marcy and said the governor had appointed her. That's oversight 9. She was then finally told on March 4th that Patty Cafferata had been appointed by the governor's staff. Now, that position was never advertised. If you remember on this board, when we advertised for Mr. Arabia, we had a posted opening for state public defender with qualifications, and this board was involved in that process. Even back then, we didn't get a lot of applicants because the pay was so low.
Right.
But here we are. So so this was all done as a total, and this goes back to what Justice Mop and a lot of us have been saying. The governor's office, which doesn't have any criminal defense lawyers, they appointed Ms. Cafferata. Now, Ms. Cafferata is a longtime, respected, very active member of a political party and is known personally and has been for years to Ryan Cherry. And he probably felt, well, Patty's solid, she's good, and I'm just going to appoint her. The problem was, by not looping us in, a person who a district attorney and a judge had complained about, and our own staff had verified, couldn't go into court and competently represent people, became the state public defender. And then she ended up going to White Pine County, and you see the reports from David Sheik, not on what the judges out there and the DAs out there have said, the concerns that they've expressed. So my point in putting this on the agenda is we need, and I believe Joni disagrees, but I can quote my rendition of what I think obligates us to, we can't tell Peter how to supervise Patty under the statute under 180, but we can certainly give guidance and Peter and guidance and advice to Peter to, in my opinion, what I would say is, Peter, you need, in other circumstances where there's one circumstance for sure where you got complaints from a judge about the performance of a lawyer in court, you restricted that lawyer from going into court on certain kinds of cases, right? Felony cases?
Yes, in a different circumstance. Yes, we have with other attorneys reduced or removed them from the types of cases they're eligible to take or be selected for.
Okay. And have you ever required substantial training from a lawyer as part of the metrics that they need to perform in order to have you and then us feel that they can go into court?
Yes, we have.
Okay. And is Brenda on this call?
I am, Laura.
Okay, Brenda, my understanding is not only has Ms. Cafferata not filled out with any adequate detail her application to be qualified on your list, but she has been offered at least two pretty substantial opportunities for training that she has not attended. Am I wrong or right, or is there more nuance to that I'm putting down?
No, that is correct. She did not include adequate information about the cases that trials that she's tried. And she was signed up or had registered for both the DIDS annual conference and the State Bar annual conference. And at the last minute did not attend either.
Okay. And just so you know, I've really done, as you can tell, a deep dive into this, because I had such faith in Marcy and her staff, still do. But I was not aware that our requirements for indigent defense don't have a time limit. So if Patty could show that 30 years ago she tried as a prosecutor a criminal case in Lander County, that would count as one of 3 felony. I mean, I think moving forward, if we can make a punch list of what we need to talk about, we need to talk about those requirements. Because I haven't actively practiced criminal defense for 20 years and so much has changed. So anyhow, I promise going to mute myself. And if anybody wants to talk about the kinds of things we could ask Peter to require of Patty, I mean, I would ask that for now she not go into court for anyone, because the videos I saw was just misdemeanor appearances. But anyhow, I'm going to mute myself. Everybody talk.
Okay, this is Chris again. So I remember when she served in the assembly. What is her legal background? I know I think she served as a DA in some of the rural counties. What, do you have to have a criminal background to be a DA, or is that just an elected position? You have to have 5 years as a JD.
Chris, her resume is on page 1.
Okay, I'm looking for it. Okay.
She graduated from college in 1961, and then there was a gap. I'm sorry, she graduated from college in 1963. Then there was a big gap, and then she graduated from law school in 1989. And if you look at her resume, she's done, I think she said this actually at our in-person meeting this summer when Marcy asked her to introduce herself. She said, I think Patty basically said, oh, you mean I can't keep a job? And she was joking, and it was,
oh, I remember that. Yeah.
Self-deprecating. But this is quite a resume, very broad with little depth, in my opinion. And she has been a prosecutor in Esmeralda County, Lander County, and Eureka County for very brief stints quite a while ago.
Okay. So I think as we make a checklist, it should not only just be for Ms. Cafferetta, but for future guidance as to what kind of qualifications the governor's office or anybody else should take a look at with regard to this position. Just so we're consistent on that. It's bothersome to me as a layperson that there's 2 jury trials coming up that she's heading up, and yet it sounds like maybe the expertise is not there. And then that flies in the face of what we're trying to do, is make sure people that are indigent have quality representation. So Peter has the authority as the acting to give direction.
Peter has the authority to fire her, but look what happened to Marcy when she just tried to get to pay some bills. Quite frankly, Peter has been put suddenly, and he's carried it with real grace, in a very difficult position. So I'm asking for us to step up, and I would suggest, I know the trial next week, and David Sheik, are you still on the phone? I think he is. I'm gonna wait for him.
I'm here.
David, do you know about you know about the first trial that Patty has next week?
Yes, I'm aware of that trial. I am not aware of a second trial.
Is that defendant out of custody?
No, he's in custody.
Oh, Lord. And they're at one felony count or several?
I believe it's one felony count of mid-level trafficking.
David, is there a co-defendant in that case?
There originally was, the co-defendant took a negotiation earlier.
And this is Allison Jaffe. That is the mid-level trafficking requires prison. Is that right, David?
It is not a mandatory prison sentence.
Okay, good. Thank you.
David, David, this is Jeff. Do you plan to be there for this trial to watch it?
Yes, I am planning to be there if the trial goes forward. There was a motion to dismiss that was filed, which has not yet been ruled upon to my knowledge. I don't expect it to be granted. And so I am planning to be there if it goes to trial.
All right, thank you.
And to that end, that shows, I mean, you don't file a motion to dismiss. I mean, Ms. Cafferata filed a motion to dismiss. You either file a pretrial habeas petition within 21 days, or you litigate the search as a motion to suppress. So we're already having trouble. I'm just going to cut to the chase. If you go through everything, and David, just tell me, because I'm tired and frustrated, if I overstate, if I become hyperbolic, but Ms. Cafferata, do you believe she would accept you becoming like a mentor, co-counsel, anything on this case?
I don't believe so. And my contract specifically excludes me from representing defendants in court that I monitor.
Well, that makes sense. Can you suggest, I mean, because anybody, see, this is the problem. Somebody just watching this, like from the governor's office, or maybe the AG's office, Todd, they're going to think, oh, mid-level trafficking, who cares? Guy's going to get what, I'm presuming this, but it's not a sympathetic thing. That's why we're here. But that guy deserves a competent lawyer. And what do we do? And Justice Maupin, you're raising your hand.
Yes, there's maybe I'm misunderstanding the exchange, but actually, the fact that it's mid-level trafficking and that he is eligible for probation actually makes the problem more complicated, because it's the judge that's going to make that decision. And so if he was in a situation where the defendant, where he was going to get convicted and would have to go to jail, that's actually a simpler problem to deal with than if they're trying to get him probation, because that means the sentencing should be a full-blown hearing to try to get him into recovery or something, whatever his problem is.
Right.
Here's the problem, looking at it through my prism. The system also has an obligation, he's in custody, to give him a trial, a speedy trial. And if he's insisted on his speedy trial rights, and I don't know whether he has or he hasn't, then there's an institutional due process problem that could create an actual dismissal of the case because of this.
What I suggest is we have an immediate problem which is this trial next week. What I suggest is that Peter and Brenda get with David and see what, if anything, could be done. If, to either continue it a week, work with the judges I mean, unless everybody's happy with, I mean, she could get a not guilty. We don't know. But what we do know is the DAs and the judges and our observer are profoundly concerned. So I
Well,
don't know.
they
Susan?
should be.
Yeah, thank
They,
you.
they should be concerned. If he's the only one left over in a plea deal and he's the last man standing as a co-defendant, then he's basically a fish in a barrel.
Susan, I agree. Susan?
Yeah, I would suggest that maybe Peter, you appoint a contract attorney to second chair that trial or to join in that case immediately. So there's some oversight. And we do have the contract attorneys that work out in that area, in that county.
Well,
Franny has her hand up.
Franny has her hand up.
I'm sorry, I'm not on the board and I won't prolong this, but the worst thing in the world to do would be to appoint co-counsel at this last minute or to substitute counsel at this last minute. What it will do is give the appearance of a whitewash of this case. This case should have been being prepared for the last 6 months. And so I know that leaves it in a dilemma, but basically what should happen is the case should be dismissed. Because the state has not provided its obligations under Gideon to provide counsel for this defendant, but sticking in a lawyer, as we've seen in at least one famous case, Margaret Rudin, in Clark County, sticking in a lawyer at the last minute to try to make it look like the client is represented would be the worst thing in the world to do, in my opinion.
But the difference was that case was forced to go to trial. If an attorney comes in, they could speak with the client, grant a continuance to properly prepare or do something different. But the only other option is it's not going to get dismissed unless it comes back on PCR, which may be, really affect this defendant's life if it's years down the line, if he does go into custody. So I think someone needs to step in now to see what remedies we can do, whether it's just a continuance, the client's in custody, get him out of custody because of the situation, file that motion.
I don't disagree with that, but I fear that that it will just appear to be an appearance of representation. And cases do get dismissed because of the unavailability of counsel. When the ABA came out with the rule that you cannot, which is actually part of the problem in this agenda, is when caseloads are too high for public defenders are obligated under the ABA rules to refuse to take clients. Cases have been dismissed because lawyers have not been available to represent the clients.
Well, and in this case, we have someone available that we have every reason to believe cannot, perform adequately. David?
There is a plea offer on the table. I mean, this case may never go to trial. I've been informed by the district attorney's office what the offer is in the case, and there's an offer that very well could be accepted when the motion to dismiss is denied.
But she is that client right now is as we sit here, and the trial's like next week, right?
Yes.
Is the somebody who comes in and represents them has got to tell the client that you have you may have a free pass on this one. No, I'm not suggesting that's how it should come out. I'm just saying that if I walked in there and I saw this business going on and everybody's saying you either have to take a plea or continue the case, the lawyer should say to them, you have a third option. And that's why I'm saying this thing is maybe too far gone to save.
Well, unless I think I'm hearing blowback. I don't know if it's me. These are every single point that's been made for this trial is disturbing, valid. I don't know if there's a good solution. Peter, reach out to whoever you feel you need to reach out to for this case and try to craft the best solution you can make. I think that, following up on what Franny said, I think it's going to be very important in this, thank goodness, at least now. I don't know what else. I don't think, David, Patty hasn't had any trials out in White Pine, has she?
Not to my knowledge.
Okay, so fortunately, you know, maybe somebody needs to inform this guy, you know, at some point, like Bill was saying, that the state messed up. And so, you know, these are his options. But I think we have to be honest. My concern for this agenda item, and I'm not dismissing it, we could go on forever, you know, on this topic, because it's not like, you know, all the lawyers and all the smart people, there's a bunch of public defenders on this call. We can't just come up and say, okay, oh, simple, we'll do this. And Peter, you're in a bad position, but it's your job, unfortunately.
Well, I'll tell you what I've already said. What I would say if I was representing this guy, they'd never forget it.
Right.
The entire institutional attack on indigent defense services would become this case.
Right. Well, let's hope the ACLU is not listening. That's a joke, Fran. Okay. But anyhow, Peter, unless somebody wants to keep talking and has a solution, I think that, you know, Mr. Goodnow, I understand that your client's at the Hoover Institution and not here, and she's got a trial starting, but, you know, if you could communicate to her, I think everybody on this call has a substantial concern about how she's going to adequately represent her client next week, and ask her to please listen to David Sheik and Peter Handy and whatever they can come up with. It shouldn't be an argument. She shouldn't go running to the governor. You know, this is something we need to handle. But then moving forward, you know, Peter, I think we do have good news. And this was also happening, you know, right before Marcy got fired, and correct me if I'm wrong, Peter, you know, Patty went to to Ryan Cherry, and then she went to Jim Wells asking for money, Marcy did. But she also, it looks like we're going to be able to have White Pine County fully staffed now, soon, and Patty won't go out there anymore.
So the workload does rely on some work from the NSPD. So Derek Penny, who's out there full time, and Jim Hoffman, who's done a fantastic job, really pitching in for just being the chief appellate deputy to handle trial level cases and doing a great job of it. So yeah, those two employees of the office, and the contract with Jane Eberhardy, who's very well known, very great at her job out there. And then we've also we're entering in the process of a contract entering with Julie Kavanaugh Bill to cover all the juvenile matters. So we should have sufficient attorney coverage for the workload in White Pine County.
That's fabulous news. Does anybody on this board have any problem? And our DAG says we can't tell Peter what to tell Patty, which I disagree with, but he's our DAG. Peter, could we urge you with great urgency to tell Patty that she can't go to court until certain metrics are met? Does anybody disagree with that?
No, but you're putting him at risk again. So maybe we need to tell Ryan Cherry that.
Well, yeah, I agree. I don't want to put Peter at risk, you know, or Brenda. I mean, you have no idea how hard they've worked ever since this happened.
Yeah.
And that office was, I mean, you do, Chris, but it was gutted. But that's why I'm doing this, you know. Marcy thought it would just resolve itself, but unfortunately, just an issue of who's supposed to pay the bills, which was clearly legally, you know, how far do we have to go protecting Peter? You know, Patty could decide she doesn't like the tone of voice that Peter talked to her in. I mean, you're right, it's a big problem. But just for now, because our main reason for existing is to protect the indigent defendants, I think the simplest way for now to do that is for Peter to tell Patty, thank you, Patty, do whatever you want, you know, happy state public defender, but please don't go to court until further notice on behalf of indigent defendants. It's a Band-Aid, but at least it'll stop the bleeding.
Joni has a comment.
Madam Chair?
Hi, Joni.
Hi, thank you. I'm not an attorney, everybody knows that, and all I tend to do is just read the statute and follow what the statute says. But I'm looking at NRS 180010 as it relates to what the requirements are for the state public defender, and there's one requirement, and that is that they must be an attorney licensed to practice law in the state of Nevada. It doesn't mention any of the other things you said, and while this certainly isn't a defense of anyone who believes that this is poor representation, maybe what we should be concentrating on is contacting a friendly legislator, and I said this during our closed session, to introduce a bill that would amend some of the sections of this statute, because this is a fault of the statute. It's not a fault of any of the individuals. There's only one requirement, and that is that they must be an attorney licensed to practice law in the state of Nevada. Thank you.
Joni, if I can respond to that, you were at the meeting where we.
Of course.
Pardon me?
Go ahead.
We have.
Yeah, no, I said, of course. Yes, of course.
Oh, thanks. And I appreciate, I know you and Patty go back, and I'm sure she's a nice person, and I also know you care.
Laura, please stop saying that. That has nothing to do with this. I do know Patty. She is a friend of mine. I am not saying any of this based on any relationship I have with her or Marcy or anybody else. I'm looking at the statute. There's one requirement. We need to fix the statute. That's all I'm saying.
Okay, and my response, I apologize, Joni, I'm sorry. We're both heated, and I apologize to you. But if you look at our regulations specifically require that if anybody, including Patty, is going to be on the DIDS list, they have certain qualifications. That applies to every public defender in the rural counties.
And that is that's very helpful. Thank you. I had forgotten about that. I appreciate it.
All right.
Laura,
Let
Laura?
me piggyback onto that, though. It makes sense that the NAC be put into statute if that's what you're going to do, because not everybody always goes back and looks at the administrative code to see what the layers are below.
Okay.
You're right, Chris. Absolutely.
Okay, well, the bill draft deadline is closed, and we have to go through the governor's office for bill drafts. But Jeff.
So I just wanted to comment as well. Joni, your reading of the statute is accurate, but that is to hold the position of the state public defender. All you have to be is an attorney.
Yes.
As has been said subsequently, in order to appear in certain types of cases, you have to have certain qualifications. For example, the Supreme Court had Rule 250 before you could do a death penalty case. That means we could have a state public defender who's qualified to hold the position, but is not qualified to go into court and do a death penalty case. We as a board have adopted other rules and regulations for different levels of felonies down the road. So you're right for her position, but not necessarily right for what she can appear for.
Yes, and I understand that, and I had completely forgotten about the administrative code, and I appreciate the reminder.
And Jeff, I appreciate as always your comments and the distinction. It was very articulate. But just to move this forward.
Laura, can I add?
Absolutely.
I think that for Peter, our advice should be to him, do what you've always done with the other defenders who have not qualified for for this position in a felony case. There's plenty of back and forth where Patty has been repeatedly requested to give us the information, or to give Peter and DIDS the information regarding felony trials. She says she has it, that's in writing, and that she will give it to us and she has not given it to us. So I think she's had adequate notice that, that this is what we need. And I think that Peter just needs to, do the same job that he's done with everybody else and indicate you have not provided the information to us. So at this point, I need to take you off of appearances in felony cases, at least. And then, you know, we'll have to deal with the fallout from that. But I think if Peter does that, you know, as everybody else is required, this is not personal. This is for who we are, professionally, to protect our indigent, defendants. And I think that, you know, I don't see how he could be fired. I hope he wouldn't be. But I think that, if we just say that, that's as much as we can recommend.
Well, but
This is-
Allison, there's a second part to that, because assume Patty 30 years ago, 20 years ago, had a felony trial for whatever, jury trial in Lander County, and assume that when she gets back and she gets through her trials, she does as Mr. Goodenow. Oh no, the first thing I guess Mr. Goodenow is she's going to respond to what we're saying now. I would ask that before that she provide the information she's required to provide to DIDS. But the second piece of that, let me just finish, Bill.
Well, I'm just doing my hand.
Oh, Peter, there's another thing, and I agree with you, Allison. It has to be uniform. It has to be applied evenly to all defenders. Peter has told us that in instances where you've had a qualified defender on the list, if there are complaints from judges or DAs or clients, I don't know, if they're actual valid complaints, he has taken them off of cases. Is that right, Peter? Maybe you could go into a little more detail.
Sure. So we haven't, that I'm aware of, removed somebody from a case, right? We haven't gone to a judge and said, remove this person from this case because they don't meet the qualifications. What we typically do is inform them of their qualification level, that we're aware that they have cases that are outside of their level of qualification, and to withdraw from those cases, and we'll find new counsel as appropriate pursuant to each county's plan. We have told attorneys you can't take this level of cases because you haven't shown yourself to be competent, or we've seen a lot of evidence of lacking the competency to take those cases. So remove yourself from any of those cases and you won't be selected for those types of cases in the future. We haven't had a situation where we've done that with an institutional office public defender. These have all been independent contractors or independent attorneys. If that helps.
All right. Now, can I ask a question of our Deputy Attorney General?
Of course.
Sure.
Is what we say here, I mean, this is a public meeting. Are you going to be interacting with the governor's office over this issue?
No, just Swampin. I don't represent the governor's office. I'd have no reason to talk to them about this.
Okay, because then I have a second question for you. Can we go into executive session over this issue about Patty Capretta? Under what circumstances can we do that?
No, at this point, it's been noticed. Everything's in public.
Okay, well, you've answered my question, and so I will now relieve my mind on a point. No good deed goes unpunished.
Laura, excuse me. Harriet would like to know, she'd like to hear what the DAG's advice is, I guess, regarding, excuse me, Patty and this trial coming up.
Well, that's what I'm going to talk about.
Okay, great.
Todd, what's your advice?
I just wanted to, Harriet, do you have a specific question, or I'm just want to make sure I'm giving you the advice as to what exactly?
Well,
you mentioned earlier that you and she disagreed on this, and so I would just like to know what your advice would be.
Yeah, no problem. So my advice was, based on my reading of the supervision statutes, that because it appears to me, and this is, Todd, the DAG's opinion, not necessarily the AG's overall opinion, but my opinion was that the supervision and jurisdiction to take action against the NSPD in any way, shape, or form lies solely with the executive director, not the board. So it was for that reason that my advice was that I did not believe the board had the authority or jurisdiction to order any sort of action as to the NSPD. However, discussion of the NSPD, I would even entertain argument that's a recommendation that the executive director take some action as to the NSPD would be okay, but that's where the line is per my reading of the statutes.
And so, Harriet, to that point, that's fine. If the board can recommend something that protects indigent defendants from being represented by someone that I have never, ever seen judges and DAs speak out like this, ever, over a period of a year and a half. It does not happen. So we have to do something. It's a recommendation. We're not going to order Peter to do anything, but to help Peter, Peter has been brilliant and loyal and a huge asset, but Peter has not he's never done this work. Many of us on this board, and even if somebody from the public comment, there's so many defenders on this call, somebody has an idea, we should do it. But for now, we just have to stop the bleeding. And I would ask for a motion, I guess chairs can't make them, recommending to Peter that Patty be relieved from all court appearances on behalf of indigent defenders until such future time that clear metrics are provided to her, and Peter Handy is now writing something, but anyway, we got to do something. Peter, you want to say something?
Yeah, just briefly, I just wanted to note that the regulations do indicate that if somebody's making an application to be on the list, that they're permitted to continue taking the level of cases to which they're seeking qualification until they're denied or otherwise. So I want to throw that out there as something we have to contend with going forward, because
right. But
the 3 days hasn't closed for the qualification period.
Peter, have you ever seen, and the other problem we have while I'm venting is we've gotten none of it. If this hadn't happened and I hadn't rolled up my sleeves and started looking into stuff, we wouldn't have known. This board would not have known, nor would Eve Hanan. Maybe not even Patty would have known about what the judges and the DA and David Sheik are observing in White Pine County. We have not gotten, because Peter has been up to his beard in, I don't know, beer bubbles or something, doing all of this work. We have 2 or 3 quarterly reports that have not been done, right, Peter? Synthesizing like David Sheik and the other observers.
Sure, yeah.
And I'm not blaming you.
Yeah.
But what do we do now? I'm not looking at, to me, we obviously have to tighten our regulations about the list. So in another century, if you tried a 2-day trial in Lander County, that shouldn't qualify, in my opinion. But what do we do now? I think we have a clear and present emergency, and under our watch.
Is Patty considered an applicant still at this point in time?
Yes, my understanding is the 30 days hasn't run since she initially put in her application.
Okay, and that is incomplete at this point.
What is she applying for?
My understanding is she's applying through category A felonies. It's easier to say what she hasn't applied for. She hasn't applied for juvenile qualification or for, I think, death penalty qualification. But Brenda could correct me on that.
Jared, help.
Well, here is, when I say this, the road to hell is paved with good intentions. Here's how the newspaper report of this will read. Indigent Defense Commission kicks lawyer off case, defendant released. Now, I'm not saying that we don't have an emergency and that this doesn't have to be dealt with that way, but what you're in a this is a very delicate situation. And to a degree, our viability as a board is right now in some jeopardy if this gets told improperly. So what I'm saying is that Patty asked for a continuance. The reason for denying it was good and sufficient from from a legal and a lawyer standpoint. But it might be better if we hold an emergency meeting and give her an opportunity to say, I need to do X or Y in response to these accusations. And that way, this person is not necessarily going to get marooned and then have a right to argue that his due process is being compromised through a political problem.
Jared, do you have any ideas?
Thanks, Laura. I wanted to follow up with Peter. Peter, you mentioned that the 30 days had not run since the application, but isn't it not that she has 30 days to submit an application? You have 30 days for which to respond to an application. So if she is not providing documents that you've requested, you can respond sooner. You just can't respond later than 30 days.
Right, I believe that's correct. Right, we can't respond later than 30 days.
So, in line with Ms. Jaffe's, position, I tend to like the uniformity aspect of that, and suggest that we consider issuing a letter, issuing a notice from the department that you have not provided proof, and in addition, there's evidence that the service is not being provided to constitutional requirements. And until such time as you complete the application and we review these, we review these complaints, you're not qualified to take the case.
Laura? Mr. Goodnow has his hand up.
Lose Laura?
Wait. Hi, wait. Can you hear me?
Yes.
Sorry.
Yes.
I just had to walk away. I don't know. You guys, should we just end this conversation because it's embarrassing, it's frustrating, and it's distressing?
No, I think let Mr. Godnow say what he needs to say, and then I think we just came full circle, and I think there's a way forward based on what Jared and Ms. Jaffe said.
Okay, thank you.
I agree with that, by the way.
This is real good now. Chairman Fitzsimmons, may I speak?
She muted herself again.
Yeah, I muted myself. We're pretty informal here.
Okay.
Yes, please
thank
do
you.
speak. Do you have a solution to this?
Well, I wanted to go back to something that Justice Maupin said because it seemed both prudent and appropriate under the circumstances. And that is that the commission schedule a meeting with Patty Cafferata in order to discuss the concerns that you have raised and any others. I also have a concern about open meeting aspects of the notification for any action taken today. I know the first notice did not specify that there was possible action, and then the second one did, and I just raised that as a concern. I don't represent Patty Cafferata in her official position. I represent her personally, but that would be my suggestion, that you take Justice Maupin up on his suggestion, and I'll make sure to communicate with Ms. Cafferata as soon as this meeting is adjourned.
Let me just ask a question because we completely relied on our DAG on these notices. I didn't know there were 2 notices. We were left out of that at that. So are you saying there's a problem with the notice? And we shouldn't even have been discussing this for an hour?
No, I think there's discussion noted on the first notice. I don't think you had noticed it up for possible action earlier.
Correct, which would be a letter or something else that comes into play.
Well, we're not
Right.
taking any action.
No, that the letter is to our executive director, and we are requesting that he take the recommendation from us as to treat Ms. Cafaretta as every other defender has had, and according to the regulations. And that's what I think that's what Jared and I are saying. If we just make that recommendation, we are treating her fairly, which we absolutely have to. We're treating our clients fairly, which is paramount to all of us, and we are following the regulations.
Okay, I want to say something, but when I made the comment about how the press might look at this and how our political, for lack of a better word, adversaries might look at it, you got to do the right thing. And we'll take care of the public relations part of it later. This is, so I'm just saying that if there's a way of, we have to be ready to deal with that kind of blowback. That's all I'm saying. I'm saying, though, that we have to do the right thing, and that a recommendation about this is not a, we're not violating any jurisdictional barriers to dealing with the state public defender's office. Does that make sense?
Kinda.
Well, I don't know where we've gotten,
Laura, let me try. You have it posted for discussion. I would suggest that we give direction to Mr. Handy from the board to counsel and uniformly meet with Ms. Cafaretta and use the same standards that are used for any other attorneys based on our administrative code. And that's all we need to do at this point in time.
I agree with that.
Okay, is there a motion? Oh, we don't have motions because we're not taking action.
You're giving direction.
Yeah. I agree with that. And parenthetically, we wouldn't be in this mess if Ryan Cherry had involved either us or Marcy in the appointment of the state public defender, as was done with the previous state public defender, who had to demonstrate the kinds of qualifications that are in our regulations. So
you're absolutely correct. But in addition to that, Laura, there is an application process, and I think Mr. Handy can proceed with how he would normally deal with other individuals to say, you have not completed it until that occurs. This is what I need to do administratively, because that is within his jurisdiction.
I understand. All I'm saying is, had we been involved, or had Marcy been involved in the selection initially of Ms. Cafaretta as the state public defender, we wouldn't be in this mess. So, but that's water under the bridge. I think that's a great solution, and we're not going to vote on it, but I'm seeing a bunch of people nod their heads up and down. Does anybody have any qualms or suggestions about this?
Hey, Laura.
Yep.
Dave Mendiola.
Hi, Dave.
So I don't really feel like it's not necessarily appropriate, but necessary for us to recommend anything to Peter, because it's already part of the process in the application. Because if we do that, then we're kind of suggesting that, well, going forward, we need to be involved in every one of these applicants' assessment. So I think they've already been doing it. We've got a plan in place. There's no reason to do it. The one concern I have is that we need to cover that other base called the governor's office. And that, in my mind, is to just protect Peter, because now we have this new world we live in because of the actions by the governor's office, where we got to check in with the governor to make sure we're doing our job right, even though they don't have a clue. So that's the only concern I have. I'm fine with recommending and that he do that, but I don't think it's necessary. But the other piece I think is somebody needs to have a conversation with Mr. Cherry. And I'm happy to be a part of that. But at least Peter should just warn them that, hey, we have a big concern with this situation, and explain why it's a big concern so that we don't get right back into the situation where there's protection of an individual that was hired and probably should never have been. So that's my recommendation, so that we don't go backwards again.
I think we all agree with that. I think those are great points.
It's a great point, but it also gets us back to the original discussion, which is the governor should not have the ability to kneecap this program. And they need to understand that. And I'm afraid the only way that that will happen is with a declaratory judgment issued by the First Judicial District, for lack of a better place, to say that your discretion with regard to this particular agency is limited. Now,
yes,
I believe that we should try to make peace with the governor's office before we make war, but usually you have to show your willingness to make war before you get peace.
Okay, anything else on this agenda item? Obviously all wonderful comments, very, very concerning, but maybe we're starting to see a path forward.
Well, I'm going to tell you one thing that I need to say before we go on. We owe you a debt of gratitude for the incredible amount of work that you have done on this, and the grace and patience with which you have done it. And so I just want to make that statement for the record, because this is the first big test of this organization. And your leadership is such that, I think that we're up to dealing with the bureaucracy of the governor's office on this one.
Thank you.
I want to second that.
Thanks, guys. All right. Well, I'm looking forward to this meeting ending and getting back to my life, but this is so important, for all of us that have worked on this. Just as an aside, I think the article's coming out next week. I'm being interviewed again tomorrow on a case that's the Washington Post is running a case that I did out of White Pine County. And it's a front page in-depth thing about this woman that was sent to prison. And I got her plea taken away because of ineffective assistance of her counsel. I mean, this is a woman I've talked to every Tuesday for 2.5 years. So, and we all have these stories, every one of us, every defender and former defender on this call, we're all flashing on those cases. So I'm just part of something that's been started long before me, and hopefully is going to continue after me, because we all know it's important. All right, let's go. Sorry, I got emotional. All right. Item 6. Now on this one, I have submitted to you, it's under emails, and I went through, I need to do some qualifiers. It's in the agenda under emails, and it's bait stamped like 1 to 191. I'm pretty sure nobody's read it all. I want to tell you where I got these. These are the emails. There was a Freedom of Information request made by the State Democratic Party to DIDS. asking for all communications with the governor's office, and that was made some time ago. I may have called the guy who I didn't know, who signed the letter, and he said they made them to all state departments. But as a result, Todd went through these emails for any kind of privilege, and I got, because they're public documents, I got a copy of them. I then went through these emails. These emails are between primarily Marcy and Jim Wells. There are other people that are on them. But and you will see when you go through these. I hope nobody that's thinking of applying for Marcy's job goes through these emails because they won't apply. And I'm not being lighthearted about that. The impossibility, the attitude, what Marcy went through trying to get money to comply with Davis. And Justice Maupin, you talk about grace, just read these. She's friendly, she's upbeat, she stresses the positive, she covers for the governor's office when they make mistakes. It's just incredible what she did. But the bottom line is that, yes, the IFC, my understanding, and I've talked to people on IFC, is they set aside a bucket of money under some kind of I don't know about money, but something, some kind of fund for DIDS compliance. But to get to that extra money, Marcy DIDS, all the things we were approving had to go through the governor's office or the governor's finance office, and I do not have access to those emails. I think there's going to be a lot more. But so a lot of things were put before IFC and were approved. But two things were never approved. From the beginning of these emails, you'll see Marcy talking about pay parity and the absolute understaffing of the state public defender's office. Those were nothing really that would have made a difference in terms of being able to hire and retain qualified defenders was ever made it through Mr. Wells onto the IFC. And then, as I already mentioned, Marcy said, okay, I guess we can't do the state PD's office. And after our last meeting said, okay, for Davis compliance, can we have this? Can we please get to this money that's already there for Davis compliance? And she was fired. So to me, and obviously this is a discussion, the impediments are the governor's office and conflicting, as we've all talked about, priorities between our charter and our mission and what the governor's office wants to do. I mean, I went to a meeting with Jim Wells with Marcy, where Marcy was trying to get money for the lawyers that were driving from Las Vegas to Ely, and Jim Wells actually said, well, why should they get paid that? I don't get paid for commuting. I live in Reno and I work in Carson City. I mean, those kinds of attitudes were just permeate these emails. And I don't know how we fix this. I'm muting myself. Don't ask my permission to speak, just everybody jump in, but identify yourselves, please.
Well, I'm Bill Maupin, and I say that if this is what is going on, and these are all public records, I say that we make a public record of what we know. And this business of kneecapping this commission because you think you have the authority over this. They really, if they do, they shouldn't. So I think that making this kneecapping job public is the first step.
Anyone else? Everybody's slammed up.
Muted myself. Sorry, this is Chris.
Hi,
I
Chris.
think we cannot assume that the governor knows all the inner workings of what's been going on.
Oh, you're right about that.
And so I do think the chair and a couple of members that might have a good relationship with Governor Lombardo should set up a meeting, not a bitch session, but just to say, here's what's happened. Your staff does what they're doing, but this has caused now an internal problem. And here are some of the results because of those problems. At least he can say, oh, I agreed with them or whatever, but at least you go to him directly, both out of respect and because never assume that they know all the intricacies of what their staff may be doing or what the repercussions from what their staff's decisions might have been. And at least that would be a second initial thing. And if Dave has a good relationship, if Joni does, then bring a couple of you together and go meet with them and you outline what you're going to do first. Secondarily, they are public record. It's very disconcerting, the tone that's there. But again, I would use that first at the initial meeting as an example of what was going on. And then if you don't resolve that, then I do think we're going to need legislation one way or another. So we need to figure out, yes, the board can go through DIDs, but you can find a legislator to do a committee bill. And so I'd be starting to work on who can do a committee bill, maybe Yeager, I don't know, Brittany, whoever. And there's some stuff that needs to be cleaned up because where we thought we protected this office and treated it differently because it's not the same thing as other state agencies, we didn't get it right. And so one way or another, we're going to have to include that better language on authority, hiring, firing, et cetera, et cetera.
Well,
Chris, I agree with you. I think we did get it right, but I think we need to tighten it up because obviously the governor's staff views it differently than we do. I think we got it right, which dovetails back with what Justice Maupin's saying, we may have to get a judicial determination, but we don't want to do that. Chris, you're right. And Dave, I will say when I met with Ryan Cherry and Nate Hastings, this was all just within days, right? And I said, does the governor even know about this? They kind of gave me one of those looks. It's like, oh, yeah, he knows. If he knows, he doesn't know. You know what I mean? He wasn't.
Sometimes you don't know what you don't know. Yes.
Right. And my understanding from, that's my grandson calling me. It's his 10th birthday. Goodbye. I'm just going to mute.
All right, I'm going to say something. By and large, Chris, you and I have basically agreed almost on politics pretty much. Have always been in sync with each other. I also have the utmost respect for what you just said because it's very wise that you give the operative person a chance. And this does not sound like, I mean, if someone did this to the governor, he would be out of his mind.
Yeah.
And when we were negotiating between branches, when we were both in the state government, the best legislation got passed through consensus. Yep. And I think that we went in there with 2 or 3 people and just say, look, we have this problem. And he can say, well, I know this and I agree with it, so get out of my office. He could say that, but I don't think he will. So I think that's a very good idea. And
then if he does say blow me off, then we have the judicial way to go. Then we do what we need to do. But at least we may, I recently was told that, and I won't use the word that they use, but assumption is the greatest of all F-ups. And it really is, because you don't always know. You go to the source, trust but verify. And so he may not know what the results of his staff's behavior did. And that's where the emails can come in. You can bring in documentation, and Lombardo's pretty reasonable on stuff like that. I think I at least found him to be. And so I think where he's not feeling like he's under attack, it's like, hey, we have a problem. We want to help try to resolve it.
I
No,
totally
and say this is our problem, yours
Right.
and
Yeah.
ours.
I totally agree. I think that we need to think about, I feel I gave that opportunity to Ryan Cherry and Nate Hastings within days, but I'm not sure that was communicated. I think if Dave Mendiola and Joni or whoever else wants to volunteer, maybe I think Jared, would be really helpful because he was in the office when it started and is intimately aware with these issues of dealing, the CISILAC, they had problems with the budget people. It wasn't like this, but, I think Jared can talk about the institutional issues. So I think if we all we can't have action on this according to Todd, and we don't need it. But I think if somebody thinks they have a good relationship with the governor and they want to join in with David and maybe Joni, she's being quiet, and make an appointment, let's do that, because I agree. I think he's a reasonable guy. I don't think he knew about it. And maybe we can, going forward, make sure this never happens again. Because
Well,
I'd like to move on unless.
I'll just say one more thing.
Sure.
I can show the governor, if I sat down in a room with him, I can show him how a larger budget for this operation will make money in the long run for the state.
That's
in
wonderful.
Millions of dollars.
So so is getting rid of the death penalty, but hey,
Ooh,
Let's not push it, Chris. But okay, let's move forward with that. We can, and since this is Todd, because we're just talking about meeting with the governor and who wants to and when's a good time, this isn't an open meeting thing, is it?
No.
No, yeah, no, that would not be official board action. That's just individuals on the board doing
All
something.
right. So
then-
we'll follow up with that.
And then this is Chris again. Can I follow up though? There was also a recommendation that we maybe have a special meeting or special agenda to deal specifically with the Cafferata issues. That's still something that needs to be pursued. And maybe Todd.
I don't think we can, Chris, because our DAG has told us, I disagree, but he's our DAG, that we can't do anything about Cafferata. It's completely in Peter's hands. I think we've given Peter enough cover for now. And thank God we've got David Sheik out there, because he is one of the finest indigent defenders I have ever known. And David's out there. And David, one thing, and Peter, I would request is for Patty and any other person that's being observed by our 3 observers, if there are complaints from judges and DAs, if there's anything even beginning in the category of what we've been hearing now about Patty, we need to know it immediately. The quarterly reports are clogged. If there's a problem, I don't care if it's an institutional defender or contract defender, forward them to the board. Not like somebody one day made the wrong argument, but if there's a big problem, we need to know about it. Does everybody agree? Okay, let's go now to number 7, report on procedure and status of solicitation of new executive director. Peter, can I summarize it? The job was finally posted because of it's not your fault, but the state bureaucracy was posted 10 days ago. Not a single human being has applied.
And they won't.
I agree. Meanwhile, what happens while that goes on is that Peter is with no pay raise and no statutory due process right like Marcy had. Peter's the acting director. Brenda is doing the other deputy stuff. And we are going into session, bill draft, and Davis compliance with let's say 33% of our lawyers taken out, but I think we can all agree Marcy was more like 60% because of her institutional knowledge and her defender experience.
So stupid question. I'm assuming Peter was appointed as acting by the governor's office.
Well, Jim Wells walked over after Marcy was walked out with law enforcement, and he was just told.
Well, I think
Yes,
that's
I mean,
something that
I
we
don't
need,
know if the governor knew anything about this.
may not, but again, if that somebody needs to ask that question, if is this an appointment by the governor? Because then he should at least be afforded those due process rights, which they ignored for Marcy. But
And a pay raise.
and a pay raise.
Well, I guess we can, you know what, you guys, if you get this meeting with Governor Lombardo, I would bring that up. I mean, that's something we need to do, and we need to post a job, because I don't think anybody's going to apply for executive director. And if Peter's the acting executive director, and for as long as he wants to put up with this nightmare, they should hire another lawyer in the office, which
Exactly.
I'm not sure somebody's going to, I hate to say it, but right now, I mean, I'm just speaking from being over there a lot of days, talking to staff. Everyone is staying there shell shocked because they believe in what we're doing. It's you walk in and people are like, I'm so impressed. Every single person in that office is doing their job and more than their job.
So
But
who generally would do the salary? Is that us or is that the
Peter?
office?
That's by legislature through the pay bill.
Okay, so it has to be through the pay bill. But this is a special circumstance. I don't know, maybe Todd, that's something you could look into statutorily. That if somebody has been placed into a new role, do they at least get that wage that comes into play?
Yeah, not an issue I've looked into. Honestly, it's something I'd probably consult with the personnel DAGs on because
Okay,
that's within their wheelhouse and they
yeah.
do a lot more often than I do. So I could certainly, make the inquiry with them if that's the board is interested in me doing that.
I think that's a great idea.
Let's start where we can maybe make some impact. And then, yes, in the governor's meeting, you should bring up, hey, is he authority? Is he, appointed by you? Then he needs to be, but we need a replacement person because we're short-staffed.
Yeah,
Right,
Todd,
because
I
we
would-
are in limbo. Sorry,
No,
Dave.
I was just gonna say, Todd, I would expect, I don't know, but I would expect that there's a working out of class clause of some sort.
Of some sort.
Maybe they don't call it that, but certainly every labor union in the state has such a clause in it.
Well, we'll have to sidestep Jim Wells. That I have never met a human being that started more intransigently, is that a word, Moppin, from a position of no. I mean, it's just no. So let's see what we can do. But meanwhile, is there anything else, Peter? I interrupted you, but on the status of the search for the new executive director.
So no, I don't have any updates. We sent it out. It's been sent out to the NACJ listserv. It's been sent out to all of our attorneys on the list. As far as I know, we haven't received any applicants. I do want to mention, since I have the floor now, that our staff has been phenomenal through this process. They really have been picking up a huge amount of slack, doing a ton of work, and really powering through. So I'm really proud of everyone in the office right now.
Well, from the board, please, a thank you doesn't mean enough, but we do appreciate it.
Okay, upcoming meetings. No, I mean, yeah, those are our upcoming meetings. I can't believe we have to do this again. I'm going to be, I think, or maybe not, in Spain. But anyhow, Kate, Mark, we have a vice chair, and Dave, I'm just kind of hoping after session you take the being chair over again, please. Okay. All right. And then public comment. I know John Lambrose. I don't know if he's still on.
Yeah, he wants to make a comment.
Good. John Lambrose wants to make full disclosure. He's my beloved husband who got me into this.
Hi. That was going to be my first comment. I think I'm unmuted. I promise you I'll be brief. I have some written comments that I want to read into this record. But before I do that, I couldn't resist the lawyer in me and the person that helped the Sixth Amendment Center and Franny Forsman and Bob Kroll and Laura Fitzsimmons and Teresa Benitez Thomas draft AB 81. in my humble opinion, and again, Mr. Todd, I read the statute a little differently than you do when it comes to the Office of the State Public Defender. That office was put into the Department of Indigent Defense Services, and that office is run by the executive director, who works at the pleasure of the Board of Indigent Defense Services, which is you guys. So it would seem to me that it's a fairly logical syllogism. If you have supervisory authority, if not firing authority, over the executive director, by definition, you have supervisory authority over the state public defender. That's my opinion. I'd like to share it with you. I completely disagree with what your lawyer said. Okay, my written comments. First, I want the record to clearly reflect that most of you know, your board chairman, Laura Fitzsimmons, is also my wife for 43 years. And I want to thank her for all of her hard work on this board, and especially the work that she's put in since the termination of the unlawful, in my opinion, termination of Marcy Reba. You members of this board are also absolutely deserving of credit. You work so hard for such a good cause, and a cause that I have been so supportive of for the last 17 years. Thank you so much. And if my voice is cracking a little bit, it's because it means so much to me. I also want to thank the members of this board that have been on this journey with me, particularly Bill Maupin, since 2007. Thank you, Bill. Thank you for your colleagues on the court for getting this ball rolling. Jeff Wells, Joni Eastley, Dave Sheik, Franny Forsman, all of you were on this board when it was the Indigent Defense Commission. And look where we are. In our wildest dreams, did you ever think we'd get this far? Save and except for what happened on that dark Friday of August 30th. I don't think anybody could have predicted that. Finally, I just want to put into this record my gratitude to Marcy Reba, her staff, and her former and current deputy directors, particularly Jared Hickman. Jared, shout out to you and your wonderful wife, Kate. Kate, those comments were amazing. Evie, the same with you. I wish, well, I won't say that. I will say it. I wish we could have heard a little bit more out of Clark County, but God bless Washoe County. Randy Fiedler, thank you for your comments from the Federal Defender's Office. I really appreciate that. And I know either Kate or Evie was speaking on behalf of NACJ. So thank you so much, NACJ, for your contribution and support. And I can tell you, Marcy deeply is in gratitude to all of you for all of your help throughout the years that she has been the executive director. To just remind you, Marcy took over in late 2019, about 3 months before the COVID epidemic. So she was getting this journey started with masks on and Zoom meetings. And with the infrastructure that she put together with those impediments, both pandemic and resource, were incredible. Because Joni, Bill, Jeff, your name is going to forever live in infamy because you have the last name Wells. So I'm just going to call you Wells from now on. Could we have imagined in our wildest dreams that we would be talking about the accomplishments of Marcy Reba and this board? Think about it. The beginning of state funding for county indigent defense. My God. You know, how many NACO meetings did we go to, Joni, where we said you have a constitutional right to have state funding?
Right.
Remember
how many hours long conversations and arguments we had about the definition of a case?
Oh my God. But here we are. And let me tell you, it's just the beginning, because if all of this goes to shit, and I apologize for my bad language, we have the ACLU, because I'm telling you, before I die, the state of Nevada is going to pay for indigent defense in total. And I think we got a friendly forum in Carson City for that particular lawsuit. We have independence from the judiciary and the prosecution in rural counties. We have performance and caseload standards. We have increased hourly compensation for lawyers such that Clark County is jealous. Clark County can't believe how much the rural counties are making an hour. You know what? Thank you, Marcy Reba. Thank you, the Board of Indigent Defense Services. Because if it were not for you, save and except the Nevada State Public Defender's Office, who of course you don't supervise. Sorry, Todd, I had to take that. I like my end of that lawsuit if it ever comes to that. And finally, the outreach that Marcy endeavored to undertake. She reached out to institutional defenders, and their offices were open for training, for oversight, for brainstorming. She reached out to the judiciary. Nevada Supreme Court justices came to and sat on panels every year. There was training. We couldn't get as many state court rural judges to these darn trainings, but we're going to keep trying. And when I say we, Marcy and Jared and Peter and Brenda know that I'm a pretty regular appearance at the Office of Indigent Defense Services on Nye Lane. In fact, I think they named one of their offices after me, but they put it in Scotch tape, so I never did really get a plaque. And finally, I'm an adjunct professor at Boyd Law School. Let me tell you the reputation that Marcy Reba has at that law school. She is held in high esteem. Eve Hanan would vouch for that, and many of the career development office, her work with law students that now are getting paid to do externships in rural counties. I mean, think about it. That never would have existed had it not been for the work that your executive director did. Now, I'm talking about 5 years of work and by a person of such goodwill and energy that got completely obliterated in one day. Now, I've heard many of you board members apologize for or at least try to mitigate what happened by saying, I'm sure the governor didn't know about any of this. Well, in my opinion, that makes it even worse because he's the governor and that's where the buck stops, as Harry Truman said. I'm encouraged, but not at all optimistic that this board is thinking about approaching the governor to see if you can work something out. But you better not give anything up, because my reading of chapter 180 is simply this. Governor, you made him. I'm not talking about going in there arrogantly. Never was a good negotiator myself, but you can't leave anything on. You can't give anything up. It took too long to get the things that we've acquired and are entitled to under the Constitution. And if you read the preamble to AB 81, the legislature was very, very convinced at that point that not only did they have to pay for this indigent defense, but they had to pay for it because it was constitutionally mandated. So don't give anything up before you make a decision as to whether or not you're going to settle. And I can tell you that in conclusion, that you do have conflict when it comes to the legal advice that you're getting. It's clear. And I think Mr. Weiss would have to admit that. You cannot be represented, you cannot be counseled, you cannot be advised at this point in your tenure as board members by a deputy attorney general. I'm sorry, I know that sounds preachy, but it just seems like conflicts 101. You need independent counsel to advise you on what your remedies are. And I'm telling you right now, I am happy to provide my time and resources in that endeavor if you can't find counsel pro bono. It means way too much to me. And Laura, I'll pledge what little separate property I have in that endeavor. But I'm happy to give up my time pro bono, but I'm too old to handle this lawsuit. But by God, I'll carry somebody's briefcase all the way to the Nevada Supreme Court, or maybe even Reno, because we might even have a federal remedy here. But I think we have a friendly forum in Carson City. So, board members, thank you for the job that you've done. I only hope that you continue to do the work that you have done. And like I said, you're at a point now where I can only hope that you don't go backwards. Thank you again, and I really appreciate all the hard work that all of you have done. That's all I have to say.
Thank you, Mr. Lambrose.
Thank you.
I can hear his voice upstairs in addition. Okay, so thank you, John, really. Is there any other public comment?
This is Chris. I do have one, and I don't know if you want to call it public comment, but not being a lawyer, after the group meets with the governor, if we do have to proceed to court, are we missing any timelines?
Chris, we're not missing any timelines. I do at all. We have maybe some other hurdles. I do have to tell you, because I saw Todd, who I've come to like, but we're fighting all the time. I saw him shaking his head when John said they have a conflict. Todd has advised us, since Joni talked about some of the conversations that we had in our, our legal briefing from the AG. Todd has advised us that not only will the AG not represent us, but the AG will not appoint, they have a statutory provision where they appoint like ex-AGs to be special counsel. They're not going to do that. And he also, Todd, correct me if I'm wrong, didn't you tell us that we don't even have statutory authority to utilize a pro bono lawyer?
Based on the very cursory review I did of the statutes, yes. But again, this is a extremely
Yes, yes, you told us we couldn't even, if we found a lawyer that would take this for free, we couldn't do it, right?
I did not see an actioning statute that allowed for that, correct?
But it doesn't say that you can't. So absence any language, then therefore we have the authority to do it.
Well,
no disrespect.
Let me add, the most important thing on this issue is it's extremely complex. It's also extremely rare to come up. So what I've said is, if the board is interested, I would be happy to start the process on requesting a formal AG opinion on this issue to give you a conclusive determination one way or the other, because this isn't something that, as you can imagine, this isn't something that comes up very often. And if it does, when it does, it's under very unusual circumstances. So I definitely don't want to steer the wrong direction or take away any rights this board may have. So I'd be happy to start the wheels going on an official AG opinion so that people who make more money than me can give you a final decision one or the other on that.
Thank you, Todd. I appreciate your
I think that's
however,
we
I don't
appreciate the offer, but with the brain power we've got on this board, I hate to say it, and the experience, I respect, I think some of you on this call may understand, I respect many of the people in our Attorney General's office, as I do the Attorney General himself, but you were so conflicted that unfortunately, I don't even think you could give us an opinion, but I appreciate the offer. We'll figure that out if and when we have to. I mean, we have all agreed that, obviously the governor may not have been briefed, and he's probably, I've heard, I don't know him, he's kind of a solid guy. And maybe, if we can bring him into this, things will change going forward. There's nothing we can do about what happened. And really functionally, the minimum of 6 months that it's cost us on the eve of the Davis deadlines. But we play the hand we're dealt. Let's meet with the governor. Let's see where that takes us. Okay.
Thank you.
All right. Thank you, Chris, so much. And don't even sound jet lagged. Okay. Anything else? That we don't have more public comment?
Hey, Laura.
Yeah.
But just one more, and I'll be short and sweet. Dave Mendiola here for the record. So I joined the board at its onset, and had the joy to work with Marcy Reba over the last 3.5 years as the chair. But in my 40 plus years, and most of that was in the private sector, running some pretty good sized companies and doing some different things like that, I've never found anybody who I enjoyed working with more than Marcy Reba. I got to tell you, not only is she top notch, gets things done, knowledgeable, but she's the sweetest, kindest person. And that gave me great joy. That's what kept me on this board. And so I just want to shout out to Marcy and the board as a whole, because I've learned so much from all of you. It's been a great time, but I feel horrible for Marcy what's happened, but I'm really excited that we're looking into fixing these problems so that we don't have to run into this again.
Dave, I think that's a perfect note to end on. Thank you. Thank you for everything, this thankless task. But, you know, what you said about Marcy, I think every one of us agrees with. So is there a motion to adjourn this meeting? What?
Chris, I'll make a motion to adjourn.
Thank you, Chris. Is there a second?
I'll second.
Thank you so much, everyone. All right. Well, take care. Thank you.
Bye.
Thank you.
Thanks, Laura.